This is a community-supported legal education channel. Find out how you can support our mission at the links in the description below. Let's go on to this dismissal of a Malibu Media case. This one is a little bit different. So if you remember, I have actively opposed cases with Malibu Media and Strike 3 Holdings. I've defended people from them. It's been the core of my law practice, and now Malibu Media seems to be dying. I only have like one Malibu Media case left, and Strike 3 Holdings moved all their cases to Florida Pure Bills of Discovery. And since I still practice, this video could be considered attorney advertising. So there, you got your disclaimer. So this is Malibu Media versus Jeffrey Duncan, and the opinion is on dismissal without prejudice. That means Malibu can file the case or claims again. The claims are not extinguished, but still dismissal is a pretty good thing to get. The court has entered an order granting a motion by defendant to dismiss the complaint against him for failure to state a claim. This opinion sets forth the reasons. Malibu is allowed to replete its claim if believed in good faith that it can cure the deficiencies. So the case is not over, it's just this complaint is dismissed. Well, we don't even see the complaint, but they're going to explain. Malibu Media does not describe itself and its business in its amended complaint. Abundant cases establish that it is a producer and distributor of adult entertainment. Its amended complaint states a single claim alleging that Duncan violated copyright protection on certain videos. Malibu accuses quite broadly that Duncan is a persistent online infringer of plaintiff's copyrights, which is the wording it uses in every single one of its complaints. Malibu Media alleges that defendant used a BitTorrent file distribution network to infringe its copyrights. It describes that network as one of the most common peer-to-peer file sharing systems used for distributing large amounts of data, including digital movie files. Malibu asserts that it used an investigator, IPP International, who established a direct TCP/IP connection with defendant's IP address. After doing so, the investigator then allegedly downloaded from defendant one or more pieces of each of the digital media files associated with 6 of its videos. By the way, this is in Southern District of Texas for jurisdiction questions. Malibu originally brought this action not against Duncan, but against a John Doe subscriber assigned an IP address. At that time, it alleged plaintiff only knows defendant by his or her IP address, and it alleged defendant's ISP can identify defendant. Malibu moved for discovery to determine the owner of the IP address. This was allowed. Malibu then amended its complaint to name Duncan specifically. To be clear, Malibu alleges only that its investigator connected over a course of time with the defendant's IP address. It does not allege that anyone ever spoke with or contacted Duncan personally, nor that its investigator observed Duncan himself engaging in the infringing content, nor that Duncan has exclusive access to the IP address. But Malibu nonetheless avers in its investigation that it established that Duncan himself personally downloaded, copied, and distributed a complete copy of works without authorization. Malibu concludes defendant is a habitual and persistent BitTorrent user and copyright infringer, and as its single cause of action, Malibu Media asserts direct infringement under copyright. Malibu states this cause of action specifically is against Duncan without further reference to an IP address. So this is their tactic. They go straight to, we know who the infringer is, but we only have their IP address, which that's such a lame and weak argument, but yet some courts really do allow the cases to continue. Eastern District of Virginia and Eastern District of PA denied my motions to quash, saying these exact same things. Rule 8A2 of the Federal Rules of Civil Procedure requires a plaintiff's complaint to provide a short, plain statement of the claim showing the pleader is entitled to relief, and you can dismiss if the plaintiff fails to say so. Read together, the Supreme Court has held that Rule 8 does not require detailed factual allegations, but it demands more than an unadorned defendant unlawfully harmed me accusation. To survive a Rule 12b6 motion to dismiss, the complaint must provide the grounds for entitlement to relief, including factual allegations that, when assumed to be true, raise a right to relief above the speculative level. I think we literally just went over this in the anime case. A complaint must therefore contain enough facts to be plausible on its face, etc. The plausibility standard is not akin to a probability requirement, but it asks for more than a sheer possibility. Review on motion to dismiss under 12b6 is constrained. The reviewing court must accept all well-pled facts as true and view them in the light most favorable to the plaintiff, and the courts generally must limit itself to the contents of the pleadings, including attachments thereto. The court may also consider documents attached to the motion, etc. Duncan's motion to dismiss is not expansive, but asserts 3 bases for dismissal. These are, first, that Malibu is an abusive and harassing litigant. Second, that its allegations concerning geolocation technology are conclusory and insufficient. And third, that an IP address alone is insufficient to identify a defendant for copyright infringement. As to the first, the court cannot properly address or resolve the assertion on a motion to 12b6, and the second and third, the court agrees and dismisses the amended complaint without prejudice. Duncan's motion essentially complains that Malibu Media targets individual defendants for harassment based on conclusory allegations of connecting to infringing conduct through BitTorrent. He states that courts have related plaintiff's actions to extortion, while noting that he is a disabled, retired person who has had a stroke. Okay, so those are definitely moral facts, but I don't think they are legal and operative facts. Malibu Media is a prolific litigant. One court recently observed that they have filed 7,183 cases from 2012 to 2018. Separate academic research tabulated that Malibu has filed 5,982 cases up to 2016, and that's the Matt Sag and Jake Haskell Defense Against the Dark Arts of Copyright Trolling from Iowa Law Review in 2018. Highly recommend you read that if you want to know more. Malibu Media's initiation of action versus an anonymous defendant is also not unusual for it. The same academic research found that Malibu Media accounted for 62% of all John Doe cases filed between 2015 and 2016. The next 5 largest plaintiffs collectively made up only another 20% of such cases. These practices extend into the Southern District of Texas. At the court's direction, Malibu filed a notice establishing that it currently has 16 cases pending in this district. The court has examined these cases, and each is like the current. Court records also indicate that Malibu Media has filed at least 304 such suits since 2016 in this district. None of these cases, or any other filed by Malibu anywhere in the Fifth Circuit, have ever reached a court for review. Or I guess have ever reached the Fifth Circuit. Scholarly criticism has emerged of this litigation as a business strategy under the copyright laws as pursued by Malibu and a few other reputed copyright trolls. Apparently Matthew Sag again. Several recent cases have also condemned the litigation practices of Malibu Media and others like it. For instance, Malibu Media versus Park, Strike 3 Holdings v. Doe. Duncan is right that some courts liken this type of litigation under the copyright law to extortion. All of this presents a genuine concern, but not on a 12b6 motion. The inquiry at present is generally limited to the face of the amended complaint and its attachments. Whether Malibu's broader litigation practices establish a defense or warrant imposition of sanctions are issues that require evidence developed in discovery. If Malibu Media repleads and continues pursuit of this action, the court will address Duncan's contentions when presented on an appropriate record. So that's nice. That means that those are going to be held open if Malibu doesn't drop it. Malibu pleads its use of geolocation technology as the exclusive basis upon which it identified not Duncan, but rather his IP address. Duncan challenges this as inaccurate. The court agrees and finds a speculative gap as to whether Malibu has plausibly identified an IP address associated with Duncan's physical address. Recall that Malibu does not allege that it actually observed Duncan engaging in infringing acts. It alleges only that its technology identified an IP address traced to a physical address located within this district. Yet the amended complaint itself pleads the accuracy limits of this technology, and it inspires no confidence. Based on experience filing over 1,000 cases, the geolocation technology used by plaintiff has been proven to be accurate to the district level in 99% of cases. This court recently observed that the Southern District of Texas covers approximately 1/5 of the real estate in Texas, spanning Houston down to the Rio Grande. This means literally millions of people live within this district. An allegation that technology accurately observed copyright infringement occurring somewhere amid 44,000 square miles and millions of people is insufficient to plausibly plead infringement by a specific person at a specific address. But based on pleading accuracy to the district level, that is all Malibu Media has done. On careful inspection, the amended complaint also contradicts any linkage between the geolocation technology, the allegedly infringing IP address, and Duncan's physical address. The amended complaint states that defendant's IP address, as set forth in Exhibit A, was used to illegally distribute the allegedly infringed videos. Exhibit A is a report or summary of the geolocation technology investigation. It lists IP address such and such and states physical location Portland, Texas. But returning to the amended complaint, Malibu Media then pleads that Duncan resides in Rockport, Texas. The towns of Portland and Rockport are more than 20 miles apart in the Corpus Christi area. Nothing in the amended complaint explains their connection. Perhaps there is one, but that is a matter for potential repleading. Given Malibu Media's current averment that its technology is only accurate to the district level, this unexplained contradiction leaves it entirely speculative as to whether Malibu Media has pled any connection to Duncan or defendant, much less a still sufficient possible one, and far from the requisite plausible one. The court grants the motion to dismiss on that basis. Then, Malibu alleges that its investigator observed infringing conduct on an IP address registered to Duncan. From this, it asks the court to make the jump from Duncan as the registered subscriber of an IP address to Duncan as an actual user of the IP address, at the times of which it complains. Duncan asserts to the contrary that an IP address alone is insufficient to identify a defendant for copyright infringement. The question is whether a mere fact that a person pays for an IP address is enough to state a claim against that person for any and all activity associated with that address. A division of opinion plainly exists on that issue. The court notes at the outset that Malibu cites 3 decisions in this district that have allowed its complaints to survive a motion to dismiss. But these unpublished docket entries are simple orders of denial. They indicate neither the issues under review nor the reasons in support. They carry no persuasive weight. Beyond this, Malibu cites a number of cases where courts have allowed its complaints to proceed, and the court has identified other decisions holding more generally on this issue that identification of a defendant based solely on an infringing IP address is enough to survive Rule 12b-6. For instance, see Countryman Nevada versus Pitts. These cases typically agree that the subscriber identity does not always correspond with infringer identity, but they nonetheless conclude that the admitted difficulty for plaintiff to later prove that the accused defendant was actually the one engaging in infringement is a question of ultimate merits, inappropriate to resolution on a motion to dismiss. In so concluding, these cases appear to improperly shift the burden in the first instance to the defendant, where the very question is the plausibility of the connection to liability, not the mere possibility, and where conclusory allegations of liability are insufficient. I've literally made these exact same arguments and had courts deny them, and it's very frustrating. The court finds that the growing weight of authority favors Duncan's position. This includes the Ninth Circuit's recent decision in Cobbler, Nevada v. Gonzalez, the only appellate decision on point of which the court is aware. Its reasoning is succinct. Although copyright owners can often trace infringement to an IP address, it is not always easy to pinpoint the particular individual or device engaged in the infringement. Internet providers can go so far as to identify the individual who is registered to a particular IP address at a particular time, I should add, and the physical address associated with the account, but that connection does not mean the subscriber is also the infringer. The reasons are obvious. Simply establishing an account does not mean the subscriber is even accessing the internet, and multiple devices can access the internet under the same IP address. The Ninth Circuit thus found it to be a situation where a complaint pleads facts that are merely consistent with a defendant's liability, stopping short of the line between possibility and plausibility of entitlement to relief. Several district courts have since expressly applied this reasoning when dismissing complaints brought by Malibu Media that are similar, if not identical, to the one here. For instance, in one case, they granted a motion to dismiss, another case granted a motion for default judgment. Other courts have also either dismissed similar claims or otherwise indicated the inherent unreliability of identifying a person solely from an IP address, etc. The BitTorrent film copyright infringement cases frames the best metaphor. Thus, it is no more likely that the subscriber to an IP address carried out particular computer function, here the purported illegal downloading of a film, than to say an individual who pays a telephone bill made a specific telephone call. And the decision underlying the Ninth Circuit opinion best frames the inquiry against the requisite Twombly-Iqbal standard, which is personal jurisdiction. When it is possible that the subscriber is also the person who downloaded the movie, it is also possible that a family member, resident of the household, or unknown person engaged in the infringing conduct. The Supreme Court has held that the mere possibility is insufficient to state a claim. The plausibility standard is not a probability requirement, but it asks for more than a sheer possibility that the defendant has acted unlawfully. Iqbal citing Twombly. Yet Malibu Media, in its amended complaint, simply converts from pleading that it observed conduct on an IP address to alleging that Duncan himself was the one doing so. I've literally made the same argument, and it's so frustrating to see it get a dismissal here and not in my cases. Like the Supreme Court in Iqbal, the court does not reject these bald allegations on the grounds that they are unrealistic or nonsensical. Instead, it is the conclusory nature of respondents' allegations rather than their extravagantly fanciful nature that disentitles them to the presumption of truth. Indeed, in both Iqbal and Twombly, the complaints failed in large measure because an obvious alternative explanation existed for the conduct at issue, which was not ruled out by conclusory averments. Malibu has not nudged its claims across the line from conceivable to plausible. It alleges no personal contact with or investigation of Duncan, and so the amended complaint contains no allegations that Duncan acknowledged personal involvement in any download or distribution, that he has exclusive access to the IP address, or even circumstances which might increase the likelihood that the subscriber is the infringer, such as defendants' living arrangements or network details. It thus remains just as possible that the IP address was used by family members, roommates, guests, friends, and neighbors, and then they recite to the Sag and Haskell defense of the dark arts of copyright trolling. Defense against the dark arts of copyright trolling. The court grants the motion to dismiss without prejudice. So that's really cool. Malibu can bring the case again as a amended complaint, like a second amended complaint or something, but only if it can overcome these deficiencies, which I believe it can't. And that's the Honorable Charles Eskridge, United States District Judge for the Southern District of Texas. That is our show, everyone. Thank you for joining me. I am Leonard French, your favorite copyright attorney. This is a community-supported legal education channel. We would not exist without your financial support. Please do consider donating on a monthly basis to our channel at patreon.com/ljfrench and sponsus.com/law. In the month of February, our $50 plus supporters are Aspernari, Video Demonetized, John Steele, Gavin Barnard, Eevi, Kyle Mudrak, Michael Pearce, Spirit Bear, Jan Negrey, Daniel Perez, Blackleaf, Joe Tyson, Benjamin Hitov, Steven, Q Grills in your area, Ottah, Kysal, and Longreach Jones. And the $5 plus supporters will be scrolling on the screen in front of me, and you will all be in the description of the videos below. Really appreciate you all. I'm gonna go rest up. Hopefully I'll feel better very soon, and I'll see you in the next video. Love you all. Bye.